Good afternoon and welcome to this 7th episode of the Legally Speaking webinar. My name's Mark Beyer, Senior Editor at Business News, and joined this afternoon by Aaron McDonald and Libby McLean from Pragma Lawyers. Welcome.
Cheers.
Thank you.
So we're going to spend about the next half an hour running through half a dozen issues, most of them related to changes that the new federal government is planning to introduce. Some of the topics we're going to cover off relate to labour hire companies and casual employment, unfair contract laws, sexual harassment issues, gender equity and insolvency. So we've got quite a bit to get through, so let's get stuck into it. So Libby, let's start with you. One of the big changes that Labor's been talking a lot about is this issue of insecure work, and they're planning some significant changes that I think will have an impact on a lot of employers. So could we kick off by talking about what they're proposing there?
Yeah, that's right, Mark. There's a lot of changes that will target what the Labor government refers to as, insecure work. Now, there's quite a number of different types of workers covered by this group, and one of those groups, rightly or wrongly, are labour hire workers. So those are workers who are supplied by a labour hire company to work in a host employer's business. What the ALP wants to do is ensure that those workers who are supplied are paid the same money and are given the same conditions for work that is done by employees who are employed directly by the host business. So what they call the same job, same pay obligation.
Okay, and I imagine that in itself could be quite interesting as to define same work, same pay. Is that contentious at all? Is that what are the sort of tests that might apply to determine if that's the case?
Very contentious, potentially very contentious. It would be fairly straightforward to work out what the same pay is for a worker doing the same job as the supplied worker, but it will get a bit interesting when there is no worker doing that job for the host employer. So you're going to have to go to a benchmark, potentially an enterprise agreement, if there's one in force for an associated entity, might provide some guidance. Otherwise, the modern award. And it will be quite tricky and quite onerous to ensure that both the labour hire company and the host employer are complying with their obligations.
Okay. So what are some of the things that a business needs to do to, prepare for the prospect of these changes coming in?
Well, this will only apply to businesses who use labour hire companies. Any business that does use a labour hire company should look at, firstly, the terms of its agreement with the labour hire company, because businesses going forward that use labour hire workers will be obliged to ensure that those terms with the labour hire company allow them various things and prevent the labour hire company from doing various things. The labour hire company will also be required under those agreements to confirm that it will meet its obligations to provide that same pay. So there are obligations on both the labour hire businesses. So if you operate a labour hire business, I would recommend getting familiar with these changes. And if you use labour hire, another thing you should probably be doing is doing a cost-benefit analysis, because this will be quite an onerous requirement. And there will also be requirements on businesses that use labour hire to ensure that those supplied workers are given all of the same opportunities as their own workers. So they will basically need to be treated the same, and they can't be prevented from being offered employment with the host employer, which may be an issue for some labour hire companies. So there's lots of things to be done in preparation for this.
Yeah, okay. One of the notes that you put there together talked about this obligation to provide information that would be reasonably required. And I know this is a phrase that comes up a lot in legal judgments and court judgments about what is reasonably required. I'm not sure if you can clarify that anymore, but I'm always intrigued by that one and interpreting that one.
The good old reasonably required and reasonable steps. It's often used in legislation and often interpreted by lawyers. I think in this context it would include information about workers who do that job, that same job that the company is seeking supplied workers for. So if they needed a bricklayer, or tends to happen in mining industry, so maybe a driller, they would need to provide the labour hire company with the details of the terms and conditions provided to their drillers. They'd need to provide evidence of the enterprise agreement or any other documents that sets out those conditions, and they would need to ensure that they continue to provide that information because pay rates change, conditions change, and it's an ongoing obligation. So it's not static.
Okay. And then perhaps more of a commercial question than a legal one, but one of the reasons that many employers take on people on different work arrangements is to give themselves more flexibility. So I suspect it could be that will be an issue, that the flexibility they get now might be taken away to a degree.
That's right. And I guess it's one of the potential ironies of these laws aimed to target insecure work. For a lot of people, what the government might call insecure work suits them quite well. And I understand that these laws are targeting exploitative and problematic behaviour in certain industries, but there are other ways of protecting those workers. I mean, they're all labour hire workers is covered by the same safety net as workers employed directly. So it is potentially difficult for both people who rely on labour hire work. It might suit their personal circumstances, and they might, frankly, get higher day rates and hourly rates by doing that labour hire work. I know mine sites particularly provide for labour hire IT providers and labour hired technical workers. They provide some pretty high rates of pay. And if this is going to make labour hire a less attractive option for businesses, then it's going to limit those workers' opportunities. It will also limit the businesses' ability to respond to labour market challenges. And there's been a lot of those lately with a very tight labour market and technological change and other things that require different workers of different specialties, which aren't always easy to find.
Okay. So moving on from that, I guess a related topic relates to fixed term contracts. So this is another area where Labor's planning some changes.
Yes.
And may have, in a similar way, may reduce flexibility, but tell us what's proposed in this area.
Yes, potentially. I mean, people on rolling fixed term contracts are the sorts of employees the government is trying to protect with these changes. And when I say rolling fixed term contracts, they're the sorts of employees who are given a 2-year contract, and then at the end of the 2-year period, they have a review, and then they're given another 2-year contract. So it's treated like it's more insecure than permanent. I mean, really, for the purpose of unfair dismissal laws, it might be considered permanent anyway, depending on the nature of the rolling contracts. But it is likely that those arrangements will be limited. So it might be the case that only 2 fixed-term contracts can be offered consecutively for the same job and position, or there can be a maximum potentially of 2 years where people can be on these fixed-term contracts. And then at that point, the employer might be obliged to offer them permanent employment.
Okay. And in relation to this, is there also some discussion around the definition of casual employees? Because I know there's been some big court rulings on this one, hasn't there? I think the 2 key ones involving WorkPac. I think there was a federal court ruling, then there was a high court ruling. So I'm not sure if that's clarified or muddied the question there.
The High Court decision clarified the question and actually provided some welcome certainty for employers. The High Court decision basically said, look at what the arrangement was at the time of contracting and whether there was a firm advance commitment to ongoing work. And if there was no firm advance commitment and the employee accepted the work on that basis, then it's a casual arrangement. Now, the Labor government is saying we don't like that decision, and we think the definition of casual employee should be more about what happens in practice on an ongoing basis after the contract is signed. Now, that creates uncertainty for employers where a casual employee might start to work more regular shifts. There's always the risk then that they'll claim down the track that despite casual loading, they were a permanent employee and should be paid annual leave and sick leave, entitlements like that. So the uncertainty is back.
Okay. So in response then, what can an employer do? You suggested maybe think about putting people onto a permanent arrangement or building up provisions for payments that might become due to casuals?
Yes, look, that's the extra cautious approach. Start provisioning for those leave entitlements if you do think you have a risk. Really, it's the same advice we're giving after the federal court decisions, which found that it's more about the arrangement going forward and the pattern and nature of the work. So really, at that point, we were telling businesses they need to review their casual arrangements. And if those arrangements look more like a permanent arrangement, that employee should be offered permanent employment and a record should be kept. And then if they still don't accept it, make a decision at that point and potentially provision for entitlements, which is a big liability.
Okay. Righto. And like with all of these things, it often gets down to the specifics of each employer and their arrangements, so people need to dig into the detail.
That's right, they do. And it's good to look at, take a sample of your casual employees and take a sample of their hours over the last couple of years. Look at who's been employed on an ongoing basis, so who's been employed for more than a year, and whose hours look a bit more regular and systematic. And then you should probably assume, well, the best practice cautious approach would be to assume that there's a risk they would be deemed to be permanent part-time.
Okay. Thanks, Libby. We'll give you a break for a minute. We'll come back to you. But Aaron, one of the other topics was unfair contract laws.
Yes.
This is part of the Australian consumer law.
Yes.
And another area where Labor's talking about making some changes.
Yes, it's a little known fact that there's this ability in contracts for businesses to assert that a particular clause in a contract is an unfair contract term. Because you'd think the standard position, the starting position in contract is that a court won't normally interfere with the parties' bargain. If they've reached a bargain, then there's offer and acceptance and consideration, then there's a binding contract. But there is the provision in the Australian consumer law for a clause in a particular contract to be declared unfair and therefore void. And that will only apply to specific types of contracts, which are known as standard form contracts, which means that it needs to involve a small business. And what a small business is has a particular definition, and the value of the contract can be up to $300,000 or $1 million over 12 months. And the contract is for the provision of goods and services, or goods or services. So if you're ticking those boxes, then you're in the potential prism of unfair contracts. And then an unfair contract term is something which is completely one-sided. To give you a small example, it's a bit like my Carlton Football Club membership, which has the clause that it renews, my credit card gets debited at the end of each year and it renews each year. Or the gym contracts, which are, you've got to go physically inside the gym to terminate the contract, but they don't have to do that. They don't have to come and find you personally to terminate. So it's completely one-sided in one respect. Those are obviously pretty minor examples, but something that's one-sided, and broadly speaking, this area of law is quite untested. There's very few decisions on it, but what they're proposing to do, what the incoming Labor government is proposing to do is currently, if a term is considered to be unfair, then it'll declare the term void. But under the new proposal, it'll be completely unlawful for a business to enter into a contract that has an unfair contract term, and there'll also be civil penalties. So the Labor government's obviously making this a priority for them. One of the other things that's going to make this area of law more widespread is that they've defined a small business now to be any business with fewer than 100 staff or turnover of less than $10 million. So that's going to cover a lot of businesses.
So that's the new threshold that will be coming in.
Yeah. So they obviously want to broaden the protection to small business for these sorts of one-sided agreements that come from up above to small businesses.
And that's absolutely clear now, or this is what we're thinking they're probably going to do?
This has been introduced into Parliament already, prior to the election actually, but they have indicated that they are going to make a point of making sure that it passes in both houses. So I guess what businesses can do, I mean, obviously when you're dealing with a large government entity or a large principal in a commercial dealing, you often do get the one-sided agreement that the small businesses wants the work and they're going to sign up to get the work. But irrespective of that, there's a chance that there might be an unfair contract term in there. So it's just, I think it's something that small business should be alive to, and big business for that matter.
Yeah, on either side of the equation.
Yeah, that's right. Yeah. Because it's in neither party's interest to have these terms included in the contract, because it will lead to uncertainty between them.
Okay, thanks for that.
No worries.
Libby, back to you. Sexual harassment laws. I mean, that's been a big issue over the last few years. There was that landmark Respect at Work report,
Yep.
and that report recommended numerous changes. We saw some movement on that front under the Morrison government, but the Albanese government is talking about going a lot further.
That's right. Yeah. They a lot of the recommendations were implemented by the past government, but the ALP government have said that they will implement the rest of them, and there are a lot of them. And one of them that will be probably the most substantial and significant for businesses is an amendment to the Sex Discrimination Act, which will require employers to take reasonable and proportionate measures to eliminate sexual harassment, sex discrimination within the workplace. Now, use of the word eliminate makes for a pretty onerous obligation, and it's much more onerous than the previous tests under, say, workplace health and safety laws, which also covered things like sexual harassment, which basically required employers to take reasonable steps to address hazards. However, this is more an obligation to eliminate this happening. So we are set for even more emphasis and focus on sexual harassment, and employers are really going to have to consider it as something they report on, something they actively address, and really take steps to ensure it stops.
Okay, because one of the phrases you've used in the notes there was talking about taking decisive action. Because I imagine lots of employers grappling with these sorts of issues, they can muddle their way through an issue.
Yes, they can.
And they might not meet that test of decisive action.
And one of the reasons why prudent employers at the moment are engaging specialist investigators to conduct workplace investigations is because they need to be able to demonstrate that they have taken these steps to really act on allegations of sexual harassment. It's not enough to, simply pay someone out and move them on and not conduct a full investigation, because an investigation might reveal that even once you remove that particular person who is the problem, you've still got a cultural problem and systemic issues with harassment and discrimination within your organisation. And there are certainly industries that have those systemic issues.
Okay. And I think I've often found in this sort of area, it's about having a structured process in place. So it's not just up to particular managers making a decision when something comes up.
Yeah,
you say, okay, we've got a mapped out process and we follow the process.
And the workers are aware of the process. So it's not enough to say we've got a beautiful detailed policy on sexual harassment. Everybody needs to be made aware of it, and everybody needs to know what they have to do if they experience it or if they observe it, and how they call it out. Now, there's also been suggestion that whistleblower policies should be updated. This issue is particularly tricky when it's senior members of an organisation engaging in the sexual harassment or the sex discrimination, and that's why the ALP is focusing on whistleblower protections and ensuring if, say, it's an exec or a CEO who's engaging in the unlawful conduct, the workers are empowered and have an avenue to report the conduct.
And you also mentioned the possibility of doing a broader cultural review. That seems to open up, that's a very wide scope there.
It is.
But that's seen as that would be seen as best practice if people go down that path?
I think, Mark, it would be best practice if your culture, if there are issues with your culture which has allowed sexual harassment or discrimination to occur. If, say, a business had a number of allegations of sexual harassment which were substantiated, and it was found that there was a culture of brushing it under the rug or enabling it, that's when a cultural review would be necessary. This isn't to say that every business should go out and engage a cultural expert and do a cultural review, but if there was an issue with the top-down management, or if there were consistent reports and those reports were being substantiated, I would recommend further investigation into whether it was a cultural issue.
Okay. And a last question on this one, but the threshold of what constitutes inappropriate behaviour, I mean, that's obviously evolved a lot over the years.
It has.
Is that clear? Or are there some guidelines to help people work that out?
Yeah, there are some guidelines, and we've seen various amendments to the Sex Discrimination Act, and here in WA we have the Equal Opportunity Act, so there's Commonwealth anti-discrimination laws and state-based anti-discrimination laws. Essentially, it's unwelcome conduct of a sexual nature. Each piece of legislation has a slightly different test, but the key elements are unwelcome conduct that would make someone feel uncomfortable, essentially, and there's that objective element that it tends to be, reasonably likely to cause someone to feel uncomfortable, or would cause a reasonable person to feel uncomfortable, and there of course has to be the unwelcome element to it as well. So it's quite a difficult test to establish, especially when you're dealing with colleagues who might be friends, there might be a bit of banter, and then there's this question of whether it was unwelcome. The investigator has to dig pretty deep to, examine the nature of the working relationship and see whether it could be considered to be welcome conduct, or whether it was not the sort of thing the colleague wanted to happen.
Okay, good. One more topic. Plans to introduce a pay equity unit.
Yes, this one is going to be very interesting. It remains to be seen exactly how the ALP will address this. The gender pay gap is a big issue for the government, and it's a really tricky one to address, I must say. So there's been suggestions that there will be a pay equity unit within the Fair Work Commission. As to exactly what it can and can't do, we're not sure. They want to amend the provisions of the Fair Work Act dealing with remuneration equality, and some suggestions that pay secrecy clauses will be unlawful for certain companies, which is quite bizarre, because I think if people are able to just openly talk about their remuneration with their colleagues, it's going to be a recipe for some friction in workplaces. So I guess the main advice there for employers is ensure you've got performance-based reasons to support pay differences between people doing the same job.
Okay, so a little unclear as to what's going to come, but I guess having good reasons to substantiate rates of pay is a good thing anyway. I would think.
That's right. I mean, when you've got a modern award, and in industries like hospitality, for example, the minimum rates are set by the modern award. So if you had a man and a woman paid differently at the same level on the same award doing the same job, then that's pretty bad. That's pretty obvious too. I think for professional services and businesses that aren't modern award covered, always having those performance KPI-based reasons to support differences in remuneration, that helps for any type of allegation of unfairness or discrimination. And if you are a bigger business, so 250 employees, you might have to report on your gender pay gap publicly, which is something that businesses should start preparing for.
All right, okay. Aaron, last topic for this discussion.
Yep.
Around insolvencies. Now we saw during COVID there was a big fall away in numbers of insolvencies, but we're seeing it's starting to tick back up again.
I think so.
Or more than tick up.
Yeah, if you speak to insolvency practitioners across the terrace, they've all had pretty long faces over the last couple of years because there haven't been the same numbers of receiverships, windings up, voluntary administrations. But if you look at the data around the most recent period, these applications are now being increased. And one of the greatest sort of catalysts in that occurring is the Australian Tax Office actually taking recovery action for people who aren't paying tax. They haven't really been doing much over the last couple of years, but they're now starting to pursue directors by issuing notices, which then causes people to go and consider some sort of insolvency event. And I just thought it would be an opportune time for businesses to consider what steps they can take to protect themselves from this, because often they are unaware that a particular customer or a supplier that they're dealing with is experiencing distress, and there are ways that they can protect against it, which are inexpensive and easy to do, but it's not surprising the number of people that fail to do it. And so I mentioned there, a pinch of prevention is worth a pound of cure. That was a line. I think Benjamin Franklin's they're known for saying that line, but it's also the former Chief Justice who used to say it. And what I mean by that is, if you have your systems and processes set up in a way where you're protecting yourself from a potential insolvency event of a customer or supplier that you're dealing with, then you are going to be in a much better position if and when something happens that's completely outside your control. So things that I would recommend, Mark, are having your terms and conditions reviewed, so the ones that you're providing to your clients or your customers, which have the proper terms in them about time for payment, security clauses. They can come in lots of different ways. You can ask for director guarantees, although very few people are willing to provide those these days, or a PPSA clause, which is the old sort of charge clause or fixed and floating charge. And then if you have those clauses in there and it's a robust set of terms and conditions, the other thing you should do is is if you're providing goods on consignment or something like that, you make sure that you have a PPSA registration in relation to the goods that you're providing, so that if the holder of the goods goes into liquidation, you can then come and pick up your goods rather than it going to the liquidator. It's only $6 to do a PPSA registration, and you'd be amazed at the amount of people that don't do it or get it wrong, and then it can have huge differences in the outcome for these people, because they go from being an unsecured creditor to a secured creditor effectively, which makes a big difference because the secured creditors are always at the top of the list of being paid out. And I'd just say things like other obvious steps, just good practice of just following up recalcitrant debtors and applying for credit searches from providers like Dun & Bradstreet that show the delinquency of potential people that you're dealing with. If you do all of those things, which are easy to forget for small businesses and medium-sized businesses when they're busy, they'll be in a lot better standing if and when this insolvency wave resumes, which I think is certainly starting to show the signs that it will.
Okay. And I imagine, I mean, just for some broader commercial context around that, the ATO's stance, I guess they're just reverting to normal practice after the COVID period?
I don't think they're back up that much yet. It was reported that they issued 50,000 director penalty notices, which means that when they issue those, the directors become personally liable for the unpaid tax of the company. And so unless they do something about it, like put the company into voluntary administration. So that's one trigger. The ATO has traditionally been the entity, it's Australia's biggest bank really. It's been the entity that has put more companies into liquidation. If you get the daily insolvency list, you can see that the petitioning creditor is always the ATO or the Commissioner of Taxation. But that hasn't happened for a long time now. When I get the list, I get it every morning. I haven't seen their name on there for some time. Maybe occasionally you'll see it, but I think it will ramp up. I mean, it's inevitable that it's not like the ATO is going to forget about the unpaid tax and let these taxpayers off. It's got to come to a head at some point. And I think now that the federal election's over, I would have thought that it's going to be an opportune time for the new government to try and get some money back.
Okay, very good. Okay. Well, look, thanks very much to those of you who've been watching this webinar. Thank you to Aaron and to Libby. We've covered a lot of ground today. This webinar will be uploaded to the Pragma website, so you can go back at a later time and watch it again, or you can refer friends or colleagues that you think might have interest in these topics so they can watch it. Once again, thank you very much to Aaron McDonald and Libby McLean. I'm Mark Beyer. Thank you for watching.